Good afternoon, ladies and gentlemen. My name is Cornelius Gabriel. I am Associate 2 in Olisa Agbakoba Legal, OAL. I want to give an insight on a subject matter that is very, very important, especially for beginners, on the aspect of debt recovery in Nigeria. So I will be talking on steps to successful debt recovery in Nigeria. To start with, as far as life exists and commercial transaction, or what I would say man and his endeavors are concerned, there is bound to be credit and debt, because that goes hand in hand with human endeavor. You do transactions, transaction can give birth to credit, and it can also give birth to debt. They are all part of business. So, what is debt? That's the first question we'll ask ourselves, because we are talking about successful steps to debt recovery. So that will first of all take us to a background question as to what is debt. Debt simply means the liquidated sum that arises either from a contract or from any form of commercial transaction where one person is indebted to the other. The person who owes is regarded as a debtor, while the person who is owed is regarded as a creditor. That said, bringing this elementary definition of what a debt is to the aspect of the subject matter of today, which is the successful steps to debt recovery, it will be pertinent to look at how does the law look at debt. There is this erroneous application or interpretation of what debt is, where it's assumed that any money claim or indebtedness of one person to another is regarded as debt. No, that is erroneous. It is not every money claim that qualifies as a debt. It becomes a debt when it is specific, liquidated. It is not in controversy. Either is admitted or not admitted, but the clarity of the sum is certain. And the Court of Appeal has even given credence to this position. In the case of NIPOST against Insight Engineering Company Limited, a 2006 decision, where the Court of Appeal held that a claim qualifies as a debt when the amount in question is liquidated, specific, or certain. So the moment it goes from the ambit of being certain, being liquidated, being specific, it now arises questions or raises questions as to simple contract, which will require interpretation, the court to adjudicate, to determine the amount in question. But when it is certain, doesn't raise doubt, liquidated, then it qualifies as debt. Having said that, we now move to the steps we have to take to recover debt successfully in Nigeria. Step 1. For you to recover debt successfully in Nigeria, the first primary step to take is to ask yourself, when did this debt arise? Bearing in mind the limitation law that might be applicable. Because according to the limitation laws applicable, you have 6 years to bring action for debt recovery. If the 6 years elapses, it will be caught up by the doctrine of statute bar. And when a matter is statute barred, it means that you can only take your action to God and not to any court anymore. So, the first step to consider is whether there is still time within to bring the suit or action for debt recovery. However, this step is what I will refer to the colonial or natural steps usually taken, which most times is commonly not taken that very serious because of the nature of our legalese, where we want to run to court for almost everything. Though that a matter might be statute bar, the first step I want to talk about, having considered whether the action is caught up by limitation law or not, is engagement. Now, engagement has been as ancient and modern as life is to our commercial transaction. In the olden days, when people are indebted to each other, it's usually by engagement. Appeal to conscience. Let the party who owes understand that this indebtedness is not good for the person's image and is not good for the continuous maintenance of the contractual relationship between parties. If engagement is on, it does not in any way forestall any result simply because the action is statute barred. The statute bar principle comes in when the only option to be taken is the step 2, which I'm going to enter after now. That is, having come to the conclusion that the matter is statute barred, and the only that the matter is not statute barred, and you have to take up action in court. But the first one I'm talking about simply states or gives the room for you to achieve result. Because one basic thing, and that is the essence of this discourse, is every client or every debtor wants to recover his money. That is the background understanding. So, though the matter might be statute barred, if indeed it is, one can still recover through engagement, which I call the first step. Now, the second step is, and let me add before I go to the second step, that the engagement can be done by the creditor himself or by retaining the service of a lawyer. So if the service of a lawyer is retained, the lawyer may either decide to start by engagement or go straight into the step 2. The step 2 is where the documents pertaining to the contract where the debt arose. And let me add at this juncture, for a money demand to qualify as a debt, there must be a time certain for the money to be repaid and a corresponding demand made when that time has elapsed and the debtor has failed to pay that money sum. That qualifies the money as a debt. So if there is no demand, if there is no time elapsing for the repayment, the money sum cannot qualify as a debt yet. So these conditions must be met or must come to pass for one to clearly say that debt has, been incurred. So, having retained the service of a lawyer, your lawyer can now be given the necessary documents if there is an offer letter, if there is an acceptance, if there is a loan agreement, if there is indemnity form, if there is any document pertaining to the transaction where the debt arose. Then the legal counsel will appraise the documents and now come up with the what you now call the action plan, having reviewed the strength of your claim. Reviewing the strength of your claim is to ascertain first and foremost whether the claim qualifies as a debt or falls under any other ambit within the civil or commercial law. That takes us to the next step. And the next step is where the lawyer will now, having appraised the strength of the case and come out with action plan, we now issue to the debtor a letter of demand. So a demand letter is sent to the debtor stating a time frame within which to pay or repay the money, failure upon which an action can be taken either in court or in arbitration. Because I say this depending on the instrument that gave rise to the debt. If the instrument that gave rise to the debt, say a deed or a contract, a form, or what have you, whichever form it comes from, stipulate that any dispute arising from the transaction should be referred to ADR or arbitration, then you must go to ADR. But if it's left open, then you have to go to court. So is that very, very important. So that takes us to the next step. This next step is where the action proper kicks off. After the service of the letter of demand and the debtor has failed, that closes the court jurisdiction to now take up the matter. You will now go to court asking the court to give you judgment on the undefended list, depending on the nature of the matter. Via what you can call summary judgment, which is why I said earlier that our courts have reiterated this position in plethora of cases, that the money sum must be liquidated. The essence of it is that the moment a debt is admitted or is certain or is liquidated, is specific, there is nothing the court has to do other than to order the person to pay the creditor. It is that very, very simple. So aside going to court for getting such order, one can also file a winding up or commence a winding up proceeding against a recalcitrant debtor, because at that juncture, all that the recovery agent or the creditor is after is to recover his money. So, and one of the conditions for a winding up proceeding to be commenced against any debtor is that the debtor is unable to pay his debt. So, and by my personal experience, I have seen that this brings a lot of results. But first, you have to be sure that that company is a going concern, If it's a company that is not a going concern, you bringing up an action for winding up is just at your own expense. If at the end of the day you have nothing to liquidate, haven't wound up the company, something to recover your money from. So the basic thing is do your due diligence. Be sure that the debtor has money or asset or property that is equivalent or you can attach, which will, be used to satisfy the indebtedness. So I think on this note, I will conclude by saying debt recovery is actually an interesting area of law in the sense that it takes you almost to every facet of the practice of law. You can recover debt that arose from any form of human existence. It could be from even professional arrangement where a debt arose. And it makes you, if you really want to get result in debt recovery, to be very, very inclined to the satisfaction of your client. So on this note, I want to encourage those who are coming into this area of law to consider these very important steps critically in order to achieve a good and great result for their various clients. Thank you very much.